Hello, everyone, and welcome. This presentation is brought to you by Megan, Emma, Norma, and Amy. Today, we will talk about demurrers, its application and use, its definition, and we will provide an example demurrer motion using the case example of Kester versus Monroe grocery store. A demurrer refers to making a pleading that challenges the sufficiency or adequacy of pleadings of another party. Demurrers typically come in two forms, general and specific. A general demurrer challenges a broader problem with the pleadings that affect all the claims brought. A specific demurrer objects to a particular problem with the details of pleading, most commonly the failure to claim sufficient facts for a cause of action. In ruling on a demurrer, the court accepts the factual assertions of the moving party as true. A demurrer does not challenge the truthfulness of facts in a pleading, just the legal sufficiency. If a demurrer is granted by the court, the case may be dismissed, or the moving party may be given time to amend the pleadings depending on the circumstances. Additionally, the motivation behind a party's motion to demurrer can be more than a desire for dismissal. In filing a demurrer, a party may be trying to gain insight into the court's perspective of the case, to know just how favorable the courts may be to the plaintiff's pleadings, or to force the plaintiff to provide more information that may be beneficial to the other party to build a more effective defense. Today we will examine Kester versus Monroe. We will soon explain that the complaint Kester filed does not include sufficient facts relating to the injury, the duty of care, and damages that support the use of demurrer in this case. Demurrer motions have an interesting history in the United States. As of 1938, federal courts in the U.S. have largely abolished the use of demurrers per the Federal Rules of Civil Procedure. This happened because attorneys came to feel that the demurrer, which requires an immediate hearing and decision at a point in the case where nothing has triggered a hearing, was irrational. However, California, along with Virginia, are the only two states that still allow demurrers to be used in state court civil procedure. Nowadays, in lieu of a demurrer, the federal government and most states replace the use of demurrers with a variation of motions to dismiss. Facts in this case are as follows. Sidney Kester is a 65-year-old computer operator. He routinely shops at Monroe grocery store. Approximately 2 months ago, while shopping, Mr. Kester slipped in the produce department and fractured his knee. Although he is recovering, Mr. Kester has missed several weeks from work and may have to use a cane for the rest of his life, as advised by his doctor. We will be filing a demurrer motion to the cause of actions Mr. Kester will use in his complaint against Monroe Grocery Store. But first, we must understand the rules that regulate and dictate how demurrer motions can be used. The grounds for the use and rules of demurrer in civil court are defined in the California Rules of Court Rule 3.1320, as well as California Code of Civil Procedure Section 430.10 and Chapter 2 of San Diego Superior Court Rule 3.2.2.
California Code of Civil Procedure, Section 430.10 through .90. The following sections of the California Code of Civil Procedure explain the grounds, timing, and procedure for demurrers. In Section 430.10, the grounds for filing a demurrer are defined as: the court has no subject matter jurisdiction, the plaintiff does not have the legal capacity to sue, if there is another action pending between the same parties on the same causes of action, and or there is a defect or misjoinder of parties. A demurrer may also be filed in response to challenge that the pleading does not state facts to provide sufficient basis for the causes of action. And finally, a demurrer may challenge that the plaintiff's complaint contains ambiguous language, and as a result, it is uncertain to determine sufficient causes of action. California Rules of Court Rule 3.1320. As of 2024, the California Rules of Court, Rule 3.1320, covers 10 very specific requirements and rules that parties wishing to file a demurrer must abide by to successfully file the motion. Beginning with, the grounds must be separately stated, meaning each ground of the demurrer must be stated in a separate paragraph and mention whether it applies to the entire complaint, to the answer, or to a specified cause of action. On that note, the rule also states that a demurrer may be filed without answering all causes of action, and it is possible to only demur to a few or to one. A party filing a demurrer must serve and file with notice the date of hearing to the other party by either electronic means, in person, or by mail. The hearing date must also be set for not more than 35 days following the filing of the demurrer. A demurrer must state on the first page immediately below the number of the case that the name of the party filing the demurrer and the name of the party who is pleading the subject of the demurrer. When a demurrer is called for a hearing and one of the parties fails to appear, the demurrer is required to be disposed unless good cause is found to continue the hearing. Failure to appear in support of a demurrer may be interpreted by the court as an admission that the demurrer is not meritorious. If neither party appears, the demurrer may be disposed, dropped, or even continued to a later time at the court's discretion. Leave to answer and amend a ruling on a demurrer, unless otherwise ordered by the court, within 10 days, with exception for detainer issues, which is only given 5 days to answer or amend. An ex parte application to dismiss following a failure to demend must be filed within the 10 or 5 days accordingly, may be made under California Code of Civil Procedure, Section 581. If the amended pleading is filed after the time allowed as ordered by the court, an order to strike the amended pleading must be obtained by a noticed motion. Unless otherwise ordered, the defendant has 10 days to answer or otherwise plead to the complaint or the remaining causes of action following: 1. The overruling of the demurrer. 2. The expiration of the time to amend if the demurrer was sustained with leave to amend. Or 3. The sustaining of the demurrer if the demurrer was sustained without leave to amend.
Demurrers, as we have covered, are mainly dictated by the California Rules of Court and the California Code of Civil Procedure. Under the San Diego Superior Court Rule 3.2.2, it clearly defines how the demurrer must be filed with local courts. In the Superior Court Rule, it states that a defendant must attach a copy of the current complaint, information, or indictment to the motion. This motion must clearly state whether the defendant seeks to dismiss, strike, or demurrer to the entire complaint, information, or indictment. If the defendant does not challenge the entire charging document, the notice of motion must set forth the counts, enhancements, allegations, special circumstances, or other aspects of the charging document that are being challenged. There are 2 court forms that may be submitted with the demurrer motion. These forms are the Declaration of Demurring Party regarding meet and confer, which is Form CIV-140, and the Declaration of Demurring Party in support of automatic extension, which is Form CIV-141. The first form is CIV-140, which is the Declaration of Demurring Party regarding meet and confer. This form is required before filing a demurrer, motion to strike, or motion for judgment on the pleadings. As we have covered before, under the California Code of Civil Procedures, Section 430.41, which went into effect January 1st, 2016, requires a defendant to meet and confer on the issues at least 5 days before the responsive pleading is due. In the bottom section of CIV 140, the demurring party must indicate under oath that either A, you met and conferred but could not reach an agreement, or B, the opposing party failed to meet and confer in good faith. In the Form CIV 141, the court is made aware that the other party refused to meet and confer within the 30 days of the complaint and requests a 30-day extension. The declaration portion in this form requires that the demurring party to either attach an additional declaration form or write out the reasons why both parties could not meet and confer under the guidelines of CCP 430.40. A motion to demur would be appropriate in this case example as the representing attorneys of Monroe's grocery store, in the case of Kester v. Monroe. Once the complaint has been filed with the court, as the answering party, we have 30 days to answer the complaint. Filing a demurrer motion in answer could be one way to either quickly resolve the case with a dismissal or give the plaintiffs the opportunity to amend their complaint with more detail, which could either help or hinder us as the defending party. With the information we were given in the scenario and the causes of action we can imagine the complaint to include, we determined that the causes of action Kester would have filed would have been insufficient to prove his claim of negligence. Therefore, in the following demurrer motion, we will explain our demurrer challenges and the legal standard that supports those challenges. In our demurrer motion, we included the following information as is required by the California Rules of Court 3.1320, as we have previously covered in this presentation. As you can see in our caption of our motion, we state the case number, parties involved, the date of the hearing, as well as the notice of the hearing within the first paragraph of the motion. In this case example, we also filed the court form CIV 140 as is required when filing a demurrer that specifically states that an agreement could not be reached per meet and confer requirements of CCP section 430.41. As we all know, motions require a memorandum of points and authorities. Demurrers are no different. Our motion is quite brief in comparison to other demurrers that would officially be filed, as we are only stating the legal standard for the motion, one cause of action, with a brief introduction to the case. We are demurring to the first cause of action Kester filed by stating that defendant demurs to the first cause of action of plaintiff's complaint on the following grounds. We then explicitly state that we are demurring to the first cause of action due to insufficient and inadequate factual basis of the cause of action stated. As we know, to prove a negligence claim, one must prove 4 elements: duty, breach, causation, and damages, fully and completely in order to successfully file a negligence complaint. In a typical demurrer for this situation, it might be more prudent to demur to all causes of action rather than just one. Then comes the legal standard in the Memorandum of Points and Authorities. In this section, we define CCP codes that support the use of demurrers, and we specifically cite the codes that are applicable to the scope and type of demurrer that we are presenting. We conclude this demurrer with a prayer for relief of the court to grant the demurrer to the first cause of action requested. Thank you very much for your attention, and we hope you've learned a few things about demurrer motions and how they may be used in civil litigation.